of a breather, either going out for fresh air or upstairs for coffee. But we are continuing this theme, obviously, of the links, and in this case, the subtitle of the panel has to do with the tensions between peace and justice. And balancing law and politics is our subject matter in this case. I am Margaret Carnes, or often known as Peggy, and Professor Emerita of Political Science at the University of Dayton, and also a fellow with the Center for Governance and Sustainability at the University of Massachusetts, Boston, because I'm now living in the greater Boston area. And it's my pleasure to be the moderator for this afternoon's session, not just because it's recompense for the board members being paid to come to meetings, but also because I think the subject is a very interesting one, and I'm pleased to be moderating the session. We are going to go in the order in which people are listed in the program. So we will be starting with Daisaku Higashi from the University of Tokyo, followed by Sash Jawaruddin, who's at the Hague Institute for Global Justice, Peter Savchuk with OPCW, and then following up, Ramesh, you get the cleanup hitter role here today in baseball terms, Ramesh Thakur from Australian National University. So without further ado, I'm going to turn it over to Daisaku Higashi.
Thank you very much for giving me such a great opportunity to share my understanding about kind of inclusivity in the post-conflict peace building and the challenge of the justice, which is my title today. I would like to mention maybe three things. One is about like a basic or a principal argument about my book, which I just published this March, The Challenge of Constructing Legitimacy in the Peace Building from Routledge. And also I will explain my experience in Afghanistan on reconciliations. And then I will briefly explain Iraq, Syria, and East Timor as a kind of complementary case, and I will make some conclusions. In order to avoid some confusions, let me explain a little bit, just 1 minute about myself. I used to work for Japanese public TV company as a program director. So I made several documentary on the international conflict, like a Vietnam War, Middle East peace talk, and North Korea nuclear issues. And in 2004, I followed like Kofi Annan, Brahimi, and Prendergast, and created a Rebuilding Iraq Challenge of the Nation, which got silver medal from UN correspondent associations. But after spending 11 years, I really wanted to be expert on the post-conflict peace building. So I started my master and PhD in the political science at the University of British Columbia in Canada. And then I had a chance to work for UNAMA, UN Assistance Mission in Afghanistan, as a team leader for reconciliations. And then I became associate professor in the University of Tokyo, but I had a chance to work for 2 years in the Japanese mission to the United Nations as a minister counselor, directing peace building commissions. So this is kind of my background, and the question on my book and the research is how can local legitimate government be constructed or eroded in the peace building process, and assuming that they created kind of democratic regimes. And I define the legitimate government as a government under which the majority of people obey its rule and institution, not by coercion, but by the conviction that compliance is kind of the right thing to do. So once the government in post-conflict state become kind of legitimate in the eye of local peoples, they are very likely to achieve kind of sustainable peace and stabilities. And I argue that there may be 4 key factors in creating kind of legitimate or eroding the government, and the role of the United Nations, inclusiveness, resource distribution. It's about like economic standard improvement, and the level of force or coercions. And my argument is, although the contemporary argument emphasizes kind of resource distribution, like money, and the level of forces, like a gun, I believe that in addition to these 2 factors, role of the United Nations, or a credible international organization, or inclusive political process are very crucial in repeating compliance with major political programs such as like election, constitutional disarmament, and creating legitimate government in the long run. So in order to support that argument, I examined Afghanistan as a major cases and 3 cases as complementary cases. I conducted academic research in Afghanistan in 2008, and as you can see, most of the area in the south and the east are already controlled by the Taliban, even in the 2008. And so I interviewed about 70 individual political and governmental leaders and the UN officials. And also I conducted kind of opinion survey in Kandahar, Wardak, and Kapisa provinces. And because of it's very dangerous, I conducted kind of group meeting and conducted opinion survey by distributing Pashtun and Dari version of the questionnaires. And in the basis of that kind of researches, I found that there is a kind of a consensus on the need of reconciliation with the Taliban in the early stages. As you know, the Taliban was excluded from the political process from 2001, and Brahimi, SLSG, in 2001 to 2004, argued that it was the biggest mistake for him not to engage with the Taliban in 2002 or 2003, when the Taliban was very marginalized and very weak. And those ideas was very shared by the Afghan government officials, like those ministers. And I also found that ordinary people also really supported the reconciliations. As you can see, 94% of people in Kandahar who are Pashtun, and 90-80% of people who are also Pashtun, which are the basis of Taliban, as well as 86% of Kapisa who are Tajik, which are minority ethnicity, responded that reconciliation is the first priority to establish a peace. So there's kind of consensus. And even for the coalition government between the Karzai and the Taliban, those number of the people supported the ideas. So I proposed creation or supporting Afghan government to create a new reconciliation mechanisms in my Japanese book published in 2009, and also report to the English report to the Department of Peacekeeping Operations. So I proposed creating a new reconciliation program and committee funded or supported by all key actors, Afghan government, International Security Assistance Forces, US, and UNAMA. And as well as creating a new reconciliation fund and the job creation centers, removing the Taliban if they enter the list or enter the program, list of the sanctions, I'm sorry, yeah. And also talking with Afghan local or Afghan leaderships. I made several presentations of this idea to a leadership of Japanese government, like a Minister of Foreign Affairs, Vice Minister of Foreign Affairs, as well as high-rank official in the U.S. Department, State Department. So in November 2009, Japanese government announced that it would support the reconciliation and integrations as one of the 3 key components in assisting Afghanistan. So then I also applied to the UNAMA simultaneously, and I got offer to work for the UNAMA as a political affairs officers, and they appreciate my individual effort to start kind of reconciliation mechanism. So I became a team leader for reconciliations. And UNAMA supported Afghan government to establish key mechanisms in July 2010, which include Afghan High Peace Council, and also Afghan peace and leadership programs, and the trust fund, which was funded not only by Japan and the UK, but also United States, Australia, Germany, which become kind of $200 million in total. But although we made some kind of mechanism in 2010, we still had a challenge in terms of making final settlement. So President Obama announced that United States is ready to have kind of political solution with Taliban in Afghanistan. In 2012, Taliban announced that it will open the Qatar office to negotiate, but it was suspended only one day. 2013, Taliban opened the Qatar office, but this time, Karzai opposed it because Taliban, showed the flag of the Taliban in the office. Last year was consumed by president elections, but this year, new president Ashraf Ghani seems to be very, passionate, and it was reported Taliban and Afghan government had kind of political talk in Qatar to start some kind of negotiation this May. So it's fluctuated, but there is some development. But when I work for the UNAMA as a political affairs officer and endorse or push for the idea of the reconciliations, we always had a strong tension between the political affairs office and the human rights office. I was quite criticized by human rights official that why do you want to promote, negotiation with the Taliban? You should prosecute them than have a negotiation. My response was that in the time of 2010, we had 100,000 U.S. officials, U.S. forces. And they fought it almost 10 years, but still 70% of the territory was now controlled by the Taliban. And the United States was ready or announced that it will, withdraw all combating force, at least by the end of 2014. So it may not be so realistic that to assume that Afghan government can, dispel all the, Taliban. So if that's the case, we might need to have some political solutions to make a stability, and even to protect people in Afghanistan. And this necessity of the inclusivity seems to be quite applicable even in the other cases. As you know, in the Iraq, the Coalition Provisional Authority led by the United States dissolved Iraq National Army, like a 400,000 Iraq National Army, which became prime candidate for the insurgency in 2003. And the United States also excluded the official of the Ba'ath Party, so the majority of the Sunni were excluded from political process. And as you know, most of the territory of the Sunni area in Iraq is now controlled by the ISIS. On the other hand, in the Sierra Leone, Revolutionary United Front, which is a major insurgency in Sierra Leone at that time, transformed itself into a political party and participated in the national elections after the Lomé Peace Agreement in 1999. Although, of course, Sankon, head of the RUF, was arrested after he took 600 US peacekeeper hostage. But it was important to recognize that the majority of RUF actually members decided to keep the peace process because they already entered the DDR processes, and also they knew that they can participate in the elections. In the East Timor's, Antite and the local leader in East Timor basically used the Commission for Reception, Truth and Reconciliations, and they investigated almost 7,600 pro-Indonesian militias. But they didn't prosecute it because they thought that it's important to establish peace in the first place. So my conclusion from at least those 4 cases is that inclusive process is quite crucial in creating sustainable peace in the post-conflict state. But the problem, which is very connected to this thesis, is that if that's the case, how to achieve the justice, especially about war crimes during the conflict. And I want to ask you, is it a matter of sequences or not? It means after we achieve kind of sustainable peace, should we prosecute or start justice process? This is, I think, one of the fundamental questions for today's international effort on peace operations. I also think that there might be very strong need or important need of accumulating lessons of different mechanisms in addressing grievance of victims of the war. I think it's very important. Even if you not prosecute the criminal of the war or conflict, it's very important to address the grievance of the victims. And there may be some, trust reception or truth and commission mechanisms, or you might have some traditional justice systems to address those issues. And I think we need to know more about how to address those issues by accumulating a lesson from the different cases all over the world. Yeah. But thank you very much.
Thank you very much, Daisaku, and thank you for keeping within our time guidelines.
I practiced twice.
Very good.
Second
Sash?
time in the book.
Thank you. Good afternoon. It's an honor to be here. I work at the Hague Institute for Global Justice under its Global Governance Program, and my research currently looks at conflict-related sexual violence. So I'm going to be talking today about harnessing the international peace and justice agendas for a more effective response to conflict-related sexual violence. Now, 2015 is a significant year for global efforts to tackle sexual violence in armed conflict, which the UN has described as a great moral issue of our time. Now, this October, a high-level review of the Security Council's landmark resolution on women, peace, and security, 1325, will take place. And within the next few months, the International Criminal Tribunal for the former Yugoslavia will deliver the first edition of its legacy project on prosecuting sexual violence, where it will set out lessons learned from more than 20 years of prosecuting sexual violence crimes at the international level. Now, there's little doubt that over the past 2 decades, the multilateral system has been at the forefront of a global normative shift. This shift has been brought about by the political and legal frameworks provided by 1325, the subsequent resolutions and initiatives that it triggered, and of course, the statutes and the case law of the international criminal courts and tribunals. Conflict-related sexual violence is no longer seen as inevitable or incidental, but rather as atrocity crimes which constitute a threat to international peace and security. The issue sits high on the international agenda. It featured prominently in the discussions of the G8 in 2013. It was the subject of a global summit championed by the UK in 2014, and is the subject of a comprehensive, dedicated policy recently unveiled by the International Criminal Court, to which Prosecutor Bensouda actually referred in her remarks here yesterday. Now, despite these unquestionably valuable gains, sexual violence in armed conflict persists. As observed astutely by the Executive Director of UN Women, quote, "Too often, policy gain rather than real impact has been our indicator of success. This must change. We must take stock and ensure that plans are action-oriented and adequately funded. Simply put, we need more results for women and girls," end quote. And I would add men and boys. So what needs to change? How to ensure that law and politics work together to produce change on this pressing issue? These are big questions, and the answers are inevitably complex. But I would like to contribute a few ideas to the solution. Let's begin with what we know about the phenomenon of conflict-related sexual violence. Now, decades of academic research have invalidated the myths and misconceptions that have plagued our attempt to resolve this issue effectively. For example, we know that sexual violence in armed conflict can be strategic. That is, it can be ordered and perpetrated to further a specific goal of an armed group. It can also be opportunistic or a matter of practice, or some combination thereof. We have powerful examples of sexual violence being perpetrated strategically from Bosnia and Rwanda, and currently in Syria and Iraq. But we also know that strategy tends to be less common than practice. That is, violence that is tolerated rather than ordered explicitly. We know that an armed group's patterns of violence can change over time and within a single conflict. We know that women can be perpetrators of sexual violence, and that men and boys constitute a higher proportion of victims than we previously thought. We also know that some of our assumptions about the cultural foundations of sexual violence in armed conflict were wrong. Patriarchy can be a necessary but not sufficient condition for sexual violence. Not all armed groups operating in patriarchal cultures perpetrate such violence, even when they engage in other brutal forms of violence. Now, this all points to a single observation with important implications for policy. Conflict-related sexual violence varies considerably by armed group. It is not equally prevalent in all armed conflicts, and it is not inevitable. We cannot address this violence effectively without acknowledging that it is not uniform and requires case-specific responses. Now, this knowledge is not, I believe, adequately reflected in the international response to sexual violence in armed conflict as a peace and security issue. I'd like to highlight 3 aspects of this response, which arguably limit its effectiveness. Firstly, it seeks to understand the issue of conflict-related sexual violence primarily by focusing on countries and conflict situations rather than armed groups. Secondly, it improperly infers global trends from select cases. And finally, it is not adequately proactive. Now let's look at this in a little more detail. Current research suggests that when attempting to understand and respond to sexual violence in armed conflict, we should engage in analysis at the level of the armed group where we observe great variation, rather than focusing on the national level. The desire to focus on states is understandable, I get it. States are the building blocks of the present international system. They drive the formulation and implementation of policy. But this does not mean that states are always the best unit of analysis for an effective policy response. Secondly, we should resist the temptation to infer global trends on the basis of case studies. Now, this has happened all too often on the international stage, with senior officials and even UN programs claiming that, quote, violence against women during conflict has reached epidemic proportions, and, quote, sexual violence has become an increasingly common aspect of contemporary warfare. Compelling cases help garner much-needed international attention, but they do not constitute a global trend. The fact remains that we don't know whether conflict-related sexual violence is increasing, decreasing, or holding steady. Even if we did have the necessary data to demonstrate a trend, it's not clear how this would help us develop more effective and targeted policies. Thirdly, our response to conflict-related sexual violence as a peace and security issue should be more proactive. Now, the Women, Peace and Security agenda, which underpins this response, has been described as resting on 4 pillars: participation, protection, prevention, and relief and recovery. Now, conflict-related sexual violence is only a small part of this broad agenda and has been addressed primarily, though not exclusively, through the lenses of protection and relief and recovery. Many of the prescribed interventions, therefore, occur during or in the aftermath of violence. Such interventions are tremendously important, don't get me wrong. But given that repertoires of violence can become entrenched over time and diffuse over armed groups, policy interventions would ideally take place before violence occurs. As highlighted by the Secretary General in his report on women, peace, and security last year, we should pay more attention to preventing violence. Policies aimed at preventing violence in armed conflict are not easy to develop. Our understanding of this violence is far from complete. That said, current research does suggest possible lines of inquiry. In addition to focusing on armed groups that do perpetrate sexual violence, we should also examine those that don't. This will help us better understand how recruitment, training, socialization, command and control structures, disciplinary systems, and ideology may influence the propensity of an armed group to perpetrate such violence. Interventions could then be based on evidence of whether and how these processes and practices influence a group's repertoire of violence. A closer link between research and policy is critical if the international system is to be more effective in its attempts to forestall violence. But peace and security is just one half of the dyad that we're concerned with here today. What about law and justice? The international legal framework that concerns accountability for conflict-related sexual violence includes the Geneva Conventions, its additional protocols, as well as the statutes and jurisprudence of the ad hoc tribunals and, of course, the International Criminal Court. The tribunals for the former Yugoslavia and Rwanda are particularly relevant. They have successfully prosecuted conflict-related sexual violence as war crimes, crimes against humanity, and genocide, contributing significantly to that same global normative shift that I referred to earlier. Now, I recognize that accountability is just one aspect of an international justice agenda, but I would argue that the pursuit of justice through accountability has contributed the most significantly to our current understanding of sexual violence in armed conflict. The need to establish individual criminal responsibility for conflict-related violence has resulted in a detailed understanding of the conduct of specific combatants and armed groups that engaged in sexual violence, as well as the patterns and purpose of this violence. This has in turn led to landmark findings of fact and law. For example, the investigations and prosecutions at the International Criminal Tribunal for Rwanda demonstrated how the strategic perpetration of sexual violence causing serious bodily or mental harm to members of a targeted ethnic group can constitute genocide. The Tribunal for the former Yugoslavia was the first international mechanism to successfully prosecute rape as a crime against humanity. And it successfully expanded the definition of slavery as a crime against humanity to include sexual slavery. Importantly, the Rome Statute of the International Criminal Court and the prosecutor's new policy on sexual and gender-based crimes reflect this enhanced understanding of sexual violence in armed conflict. Now, while the liability framework of international criminal law facilitates a detailed examination of the sexual violence perpetrated by combatants and armed groups, there are limits to the understanding of this violence that can be gained through international criminal law and legal proceedings. Judgments are particular to the facts of a given case, the charges brought by the prosecution, and of course, applicable law. International criminal law also generally focuses on those bearing the greatest responsibility for atrocity crimes. That is, the political and military leadership. Judgments do not capture sexual violence if the evidence doesn't meet the standards of proof, if the crimes of sexual violence are not charged by the prosecution, if these crimes occur outside the time period or the crime bases under consideration, if they're committed by perpetrators in lower ranks, or whose behavior does not fall within the normative framework of war crimes, crimes against humanity, or genocide. Additionally, accountability mechanisms are inherently reactive. They cannot act until a crime has been committed. Now, many would argue that prevention through deterrence is an important goal of international justice. But the fact remains that we don't know whether this goal has been or can be achieved. The deterrent effect of international prosecutions is difficult to measure. So where does this leave us in our efforts to address conflict-related sexual violence? And what does it tell us about the relationship between peace and justice? To improve the effectiveness of the international peace and security agenda for sexual violence in armed conflict, evidence-based policy that relies on appropriate analytical lenses, acknowledges the limits of our knowledge, and seeks to anticipate rather than react to violence is imperative. As for the international justice agenda, accountability is a critical component of international efforts to mitigate conflict-related sexual violence. It influences strongly the global narrative surrounding this issue. It establishes a historical record of the atrocities that have occurred, and it provides some measure of relief to the survivors. But the justice agenda is necessarily a narrow one. It is constrained by the form and function of justice mechanisms and legal frameworks. The international peace and justice agendas have, then, unique strengths and weaknesses. I believe that they are most usefully viewed as complementary works in progress. The justice agenda facilitates a depth of analysis into the conduct of armed groups that is incredibly useful, while the peace and security agenda offers greater scope for a holistic understanding of sexual violence in armed conflict, and it offers a basis for preventative action. Importantly, in the case of conflict-related sexual violence, these agendas are, and always have been, inextricably linked. The ad hoc tribunals were created by the Security Council to reestablish peace and security through justice. Neither the tribunals nor the International Criminal Court would have received a mandate to investigate and prosecute conflict-related sexual violence, or have been able to do so successfully without the requisite political will. Similarly, without the courts and tribunals, our understanding of the nature, causes, and consequences of sexual violence in armed conflict would be far less developed, and our recognition of the gravity of these crimes more equivocal. International efforts to address sexual violence in armed conflict have highlighted that the alliance of law and politics, or peace and justice, is a powerful one. It also needs to be an effective one. This requires that our efforts are guided by evidence rather than opinions, and anticipate rather than react to the challenge that confronts us. Thank you.
Thank you, Sash, for most interesting set of remarks and presentation in this regard. Peter Sajja? Yes.
I should say from the outset that I'm not a lawyer, but I am an international civil servant, and And I'll leave to you to determine which profession is more tedious in terms of presentations of viewpoints, how canonical they have to be, but perhaps I might try and balance it out with my well-rounded experience as a diplomat to make my comments a little philosophical and worldly as much as I can. So before I launch into my remarks, I'd like to make clear from the outset that in addressing this topic in broad terms, we need to avoid equating politics with peace and law with justice. That's far too neat, perhaps a dichotomy, and certainly perhaps even a false one. I also want to make clear that our work at the OPCW, which I represent, relates more perhaps to peace than to justice, at least justice in the sense perhaps envisaged by this panel. But I'll try to show how our work at the OPCW can be part of a broader effort to effect justice, beyond simply justice for our states parties under the Chemical Weapons Convention, in terms of their responsibilities and rights. So with this in mind, let me start by stating the obvious. Law and politics are part and parcel of the functioning of any multilateral organization, especially one that is treaty-based, like the OPCW. But whether or not this really amounts to a balancing act depends on the degree of political will and evidence, as well as the strength of the legal norm that is being upheld. With 190 states parties, which hopefully soon will be even more, we have a truly global norm in the form of the Chemical Weapons Convention. And as my legal colleagues tell me, its prohibitions are now indeed part of customary international law. What is more, our decision-making within the OPCW on implementing this treaty has been consensus-based, not because of any requirement, but rather because of practice that is now based on long-standing habit. But even more remarkably, perhaps, in the world of multilateralism, our lowest common denominator has been remarkably high. This has been very well evidenced by what we've been able to achieve over less than 2 decades since the entry into force of the CWC. We have, as I mentioned, 190 states parties, near universal membership. We announced last week only that so far we've destroyed 90% of all declared chemical weapons across 98% of the world and its population. We've had more than 2,500 inspections in more than 85 or so countries around the world, and not to mention that we also got a Nobel Peace Prize in the process. Now, this all brings me back to the question of political will I foreshadowed a moment ago. If we look back a little bit over past history, this was indeed the main ingredient in the very hearty soup that became the Chemical Weapons Convention in 1992. It also saw the convention enter into force only 4 years after it was opened for signature in 1993. So the reasons why the convention is the most successful disarmament treaty in history are manifold. If we cast our minds back in time to when it was negotiated in the 1980s, I'm certainly not an apologist for the convention. I have to support it as being the best treaty. I think we were also victims of very, very fortuitous timing. The treaty was negotiated in earnest through the 1980s, at a time when major powers decided that chemical weapons had dwindling battlefield utility, at a time when the public and indeed negotiators' minds were focused on the dastardly nature of chemical weapons because of what was happening during the Iran-Iraq War. And thirdly, we benefited from a new spirit of cooperation, of course, at the end of the Cold War. Without the US and Russian buy-in, this could not have happened, could not have been as comprehensive an instrument as it indeed became. So together, these factors helped to cement a very high degree of political will for the mission encapsulated in the convention. I hasten to add here also that political will was also assisted by the participation of a broad section of stakeholders in the negotiations on the convention. Scientists, to make sure that the verification regime we built was credible in terms of its methodology and techniques, and industry also, to make sure that their commercially sensitive information was well guarded in the course of routine industry inspections, to make sure no facility that could make chemical weapons was indeed doing so. So political will is understandably all the stronger if grounded in measures that guarantee transparency, security, and of course economic well-being. Now, I won't comment on the failure in other areas of disarmament to achieve a treaty that is at once non-discriminatory and verifiable, like the CWC, but clearly political will is a mandatory baseline. The strength of political will supporting global chemical disarmament has, of course, been nowhere more in evidence than in the remarkable international effort to eliminate Syria's chemical weapons program. Now, it's worth recalling the main elements of this effort to understand why this indeed was the case. The international outcry against the confirmed use of chemical weapons in the Damascus suburb of Ghouta in August 2013 precipitated quite an extraordinary series or succession of events. Directly afterwards, Syria decided to join the CWC. The US and Russia, within days, I think two, negotiated a framework agreement in Geneva which set out the parameters for a program to eliminate Syria's chemical arsenal. A few short days thereafter, in the Executive Council of the OPCW, we came up with a decision for a program of destruction, and to backstop that, the Security Council passed Resolution 2118 unanimously. And thereafter, we had inspectors on the ground within 3 days, and we quickly established the OPCW UN Joint Mission. Now, I won't go into the details of this very complex and unprecedented mission undertaken, as we all know, in circumstances of a very bloody civil war and in highly compressed timeframes. But I might highlight three things that stand out for me in relation to this mission, in relation to the purpose of this particular panel. First, there was no need for a specially mandated ad hoc international mechanism to govern this process of elimination, since the Convention basically provided a ready-made, tried and tested vehicle for doing that. Secondly, to bend the letter of the law to better achieve its spirit and the practical results that we did, our states parties authorized the transfer of Syrian chemical weapons out of the country. And this was achieved, as I mentioned, through endorsement of our Executive Council's decisions on the program of destruction by UN Security Council Resolution 2118. Because under the Convention, strictly speaking, or directly speaking, a state party that is a possessor state, has chemical weapons, is supposed to get rid of them at their own expense on their own territory. We made an exception here. And thirdly, at no point was this very costly and logistically highly complex mission undersubscribed. We had very generous in-kind and financial assistance from more than 35 countries. And in-kind was things like the US putting on a large ship with two devices, field deployable systems, to eliminate the most dangerous of the weapons from Syria's arsenal, as one example. Now, we've largely done this. So within basically 1 year of that Executive Council decision on the 27th of September 2013, all declared chemical weapons were removed from Syria, and all the most dangerous ones were destroyed. So this was not obviously a case of balancing law and politics, but rather of one of them mutually reinforcing each other, based on the very strong consensus underlying the strategic goals of global chemical disarmament, even to the point, as I mentioned before, of bending the letter of the law to achieve a practical result. But let me point to one more case, if I can go beyond the purely technical and stray into turf, perhaps I shouldn't. One other thing that demonstrates the very strong convergence of national interests on chemical disarmament is of interest in relation to this panel, in the sense that at that time, the civil war had been raging for 2 or 3 years in Syria. Chemical demilitarization was the only point on which we could get international consensus. Now, this also had a bit of a diplomatic afterlife. You might recall the Geneva II process came in the wake of agreement on demilitarizing Syria chemically. Now, that process failed, but what I want to say is that the consensus that we were able to draw from the historical consensus we've had on chemical weapons being taboo had a broader application in relation to try and peacefully resolve a conflict. So despite all these successes, you'll all be aware, of course, that there is some unfinished business in relation to chemical weapons in Syria, and some of which extends beyond the strict mandate of the OPCW. 2 missions have been conducted so far in relation to allegations of use of chemical weapons in Syria. The UN investigation, which I mentioned, drawing on OPCW expertise that confirmed the use of sarin in August 2013 in Syria, and the ongoing OPCW fact-finding mission, which has been looking into allegations since last March, last year, of use of chlorine gas as a weapon. That mission has concluded that chlorine had been used as a weapon systematically and repeatedly in 3 villages in northern Syria. But what these missions have not been mandated to do is determine the perpetrators, which of course is important for the justice equation in relation to our topic here today. So just to be clear on this in relation to our fact-finding mission, this mission presents its findings, as it's done so far on 3 separate occasions in 3 separate reports, and it's then up to the policy forums made up of our member states to decide on the next course of action. To this end, you're probably aware of an initiative in New York to set up an independent international inquiry to identify the perpetrators in pursuance of UN Security Council Resolution 2209. I'd note in this regard that while our own mandate is limited to investigating allegations of use of chemical weapons, it's of course up to our states' parties that have passed national legislation under the Convention to prosecute those responsible, or for international courts with jurisdiction over those offences to do so themselves. It's here perhaps that the tensions between peace and justice make themselves most keenly felt, when politics determines perhaps the context in which law can operate. But as an international civil servant, I'll leave you to debate the political dynamic within the Security Council on moving towards accountability in relation to the use of chemical weapons, or what might motivate states' strong opinions on what constitutes evidence, which Sash referred to before, in a court of law, or even lesser investigations. So in wrapping up, and to avoid leaving you with the impression that I'm a shameless propagandist for the OPCW, I just point to the fact that our organization is now facing a real risk of losing some of the support we've had to date because of the changing nature of our mission. I mentioned that 90% of chemical weapons have now been verified by us as destroyed. What next? Now, the mission to prevent the re-emergence of chemical weapons, extraordinarily important given the threat of chemical terrorism, will require us to do something that's publicly less visible and that's qualitatively much harder to do. More immediately, we'll also need to negotiate the space between our confirming the use of chemical weapons and others attributing blame. This could have repercussions for how our own member states engage on new and emerging threats, perhaps even have some impact on how we do our own decision-making in that organization. So finally, when we were awarded the Nobel Peace Prize, there was some talk about what lessons can be drawn for disarmament more broadly, based on the successes of the OPCW. To my mind, we don't have to look any further than the fundamental and perhaps exceptional circumstances of how, in the case of the CWC, political will was able to create a legal regime that can account for tangible results. So my sense is that any situation in which politics and law play a mutually reinforcing role can only help expand the road of disarmament into one of peace and perhaps better lead it towards justice. Thank you very much.
Thank you very much, Peter. And finally, our last presenter is Ramesh Thakur.
Thanks, Peggy. The title of this panel is Balancing Law and Politics: What are the tensions between peace and justice? If law and politics are to be balanced as a means of reconciling the tension between peace and justice, then power must also be inserted into the equation. And my theme is the tension between ground and global realities of power on the one hand, and local and international justice on the other. Two essentially normative concepts and how they connect to peace. For example, in the Middle East, the region with the highest conflict intensity and the most Nobel Peace Prizes, no peace agreement will be possible without accommodating the reality of Israel's dominant power backed by US might. But no peace agreement will endure without justice for the dispossessed Palestinians. Such light and easy topics. No wonder they've allocated us just 15 minutes each. Let me make 4 points briefly. First, my talk lies at the intersection of 2 major trends. The first is a long-term shift from the power end of the spectrum towards the normative end as the pivot on which history turns. The second is the contemporary realignment of the global power equations as the pendulum of history swings back to dilute the relative role and influence of the West in structuring world order. On the first, throughout history, strategists have been cognizant of this stern admonition from Athens to Milos, that questions of right and justice apply only to relations among equals in power, while for others, the strong do what they can and the weak suffer what they must. Yet subsequent history has modified the thesis. Over the centuries, the pendulum of human behavior has swung surely, albeit slowly and in a jagged rather than linear trajectory, from the pure power towards the normative end of the arc of history. On the second, the West is losing its ability to impose its will, policy preferences, values, and double standards on the rest, who are demanding their rightful due in setting the standards, writing the rules, and designing and controlling the institutions of global governance to ensure compliance. In other words, a much-needed global moral as well as geopolitical rebalancing is in train. Second, the logics of peace and justice can be contradictory. Peace is forward-looking, problem-solving, and integrative, requiring reconciliation between past enemies within an all-inclusive community. Justice can be backward-looking, finger-pointing, and retributive, requiring trial and punishment of the perpetrators of past crimes. The ethic of conviction would impose obligations to prosecute people for their past criminal misdeeds to the full extent of the law. The ethic of responsibility imposes the countervailing requirement to judge the wisdom of alternative courses of action with respect to their consequences for social harmony in the future. However, it is also possible to build a case for international criminal justice as a solution to the problem of peace and reconciliation after mass crimes in fractured societies. After all, Allied powers and Germany are at peace not despite Nuremberg, but because justice cleared the path to reconciliation. We had a very good presentation, keynote address last night from the prosecutor, and the point was made that the African Union collectively and several key African states, but by no means all, and certainly not all of African civil society, have challenged the operation of the ICC on two main grounds: that it has been obsessively Africa-centric while ignoring other cases worthy of its attention, and that it has ignored politics in privileging law and in the process undermined the efforts to seek peace by focusing exclusively on the pursuit of justice, the very tension I have just canvassed. On the big picture canvas, this controversy, I think, intersects with both the major overarching trends that I have mentioned. But it does raise the question, are the most powerful countries using the United Nations and the ICC as instruments of control to keep the leaders of non-deferential, weak countries in line? Pay us the respect due to us, or we will make you pay for your lack of respect. Remember, the UN Security Council is not just a quintessential, but the world's supreme political body. Therefore, when international criminal justice is administered by the Security Council, can it avoid being politicized justice? Remember, no less a person than Desmond Tutu refused to share a stage with Tony Blair. It will be very damaging, I believe, to international criminal justice as a political project if in Africa and more widely around the world, many conclude that crimes were committed in Iraq, but that the likes of George W. Bush and Tony Blair will get away with it. The social purpose of the ICC will then be seen to provide the ideological justification for the current geopolitical order. Third, the tension between power and justice typically is manifested in double standards, with the powerful brushing aside the demands of justice, with deleterious consequences for sustainable peace as opposed to temporary truce. Let me give you 3 examples. Peter, being an international civil servant, stopped short of appropriate lessons for other WND regimes arising from the CWC. As an ex-civil servant, I don't have that restraint. The powerful have pushed aside any conception of justice to protect and promote their interests, thereby endangering peace. The NPT was meant to reconcile power and justice. Those without force for the option in return for those with, promising to eliminate their nuclear weapons. Over time, however, the NPT was subverted from a prohibition into a non-proliferation regime. Not one country with nuclear weapons has made elimination the central organizing principle of its nuclear policy. To the contrary, all of them foresee indefinite retention of nuclear weapons well into the future. Consider the negotiations over Iran. Who are the negotiators on behalf of the international community? P5+1. The P5 have weapons in the numbers 8,000, 7,300, 250, 300, and 225. And the +1 doesn't have its own nuclear weapons, but does have more than 100 nuclear warheads on its soil. How many does Iran have? To the best of our knowledge, 0. So, in other words, those who worship the most fervently at the altar of nuclear weapons issue the fiercest fatwas against anyone else wanting to join their sect. Power politics, you bet. Justice, yeah, right. Result, nuclear peace is imperiled. Second example, US exceptionalism. Exceptionalism as belief in a uniquely virtuous republic with a moral mission to export life, liberty, and happiness to the rest of the world is clearly hardwired into the US national identity and likely to endure. Exceptionalism as policy was dependent on the unipolar moment of full spectrum dominance and is fatally undermined by the transformation into a polycentric global order. But Washington's attempts to browbeat China, India, and Russia with respect to cyber espionage, maritime territorial disputes, domestic US visa and labor laws, international human rights law, and respect for the national sovereignty and territorial integrity of Ukraine fail the rule of law test. Quote, a principle of governance in which all are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated. From Kofi Annan in 2004. In all 3 cases, the United States held others to standards of domestic or international law that it demonstrably ignores or violates itself, and tried to impose costs for their transgressions that it has refused to pay for itself. Now, at West Point on 28th May last year, President Obama insisted, quote, the United States will use military force unilaterally if necessary when our core interests demand it, unquote. In his speech to the General Assembly in September, he insisted that, quote, all of us, big nations and small, must meet our responsibility to observe and enforce international norms, unquote. The 2 statements less than 5 months apart are not compatible. If you insist on preserving the right to use force unilaterally if necessary, you are not respecting international norms and the rule on the use of force. The third example of double standards in a slightly different context. And I'm sure this audience would be profoundly disappointed if I did not try to smuggle in a mention of responsibility to protect, regardless of the topic. The state was granted the monopoly on the legitimate use of violence in an effort to limit the violence of anarchy. That is, as a means of achieving peace in domestic affairs. Any resulting injustice was accepted as collateral damage on the grounds that justice was impossible in conditions of anarchy. Over time, the right to intervene in other countries' internal affairs was also progressively curtailed, this time as a means of limiting international violence, that is, maintaining international peace. In the post-colonial era, the formerly colonized were interested in pursuing justice among states, but under the impact of an increasingly internationalized human conscience, many Western publics and a few governments began to express interest in promoting justice inside sovereign jurisdictions in accordance with international normative benchmarks. And this led to a revival of interest in so-called humanitarian intervention that produced an equally strong adverse reaction from the global South. In telegraphic form, it seems to me that the old language of humanitarian intervention was an example of power appropriating the language of justice to serve power. Responsibility to protect is an effort to harness power to the cause of domestic and international justice. And we see controversy in Libya because NATO, I think, appropriated UN-authorized responsibility to protect to pursue power political humanitarian intervention. There was a conflation, and that, I think, is responsible for the controversy. But the fourth and final point, the rule of law. It seems to me that the best, most effective, and least problematic formula for reconciling power and justice in order to promote sustainable peace, because it will be a just peace, is through deepening the commitment to and institutionalizing the rule of law. By way of conclusion, the sense of justice, fairness, and equity is deeply ingrained in human beings and perhaps even in primates. There's very interesting experimental research with monkeys, where if you offend their sense of justice, they will throw away their rewards that you've given them in anger. The neighboring monkey having been given more for having done the same job. One of the most powerful refrains in any society is, "That's not fair," leading individuals to resist and disobey, and groups to rebel and revolt. The importance of perception as well as the content in the administration of justice is captured in the familiar saying that justice must not only be done, it must also be seen to be done. The justice sentiment is expressed in collective norms and, in a general sense, in laws. In particular instances, laws may offend the prevailing sense of justice. If the dominant perception is that law mostly conforms to notions of fairness and justice, the odd anomaly will not pose a threat to the system of laws. But if the opposite perception takes hold, that any convergence between law and justice is coincidental, and normally law is seen to have marched off on a tangent from justice, then the system of law and the principle of a community based on the rule of law will be brought into disrepute and collapse under the weight of illegitimacy. Thank you.
Thank you very much, Ramesh, and I am reminded that you truly have fulfilled the traditional role in baseball of the cleanup hitter, which is the reliable hitter, in this case to be provocative on the subject at hand, and you have indeed provided us much food for thought in that regard. I have just a couple of comments myself, and then I'm going to open it up to the audience. We have a floor microphone here, and because oftentimes it's been hard to hear questioners, I'm going to ask that you move to the microphone if you wish to raise a question, unless you know that you truly can project your voice so that everyone in the room can hear it. And we have the table mics here for the panelists as well. But I was reminded particularly with Daisaku Higashi's remarks, having spent so many years in Dayton, Ohio, where the Dayton peace negotiations took place. Ironically, that was the year I was at the Johns Hopkins Center in Nanjing, watching CNN International with negotiations taking place at Wright-Patterson Air Force Base outside of Dayton. But I've been struck, I have taught the case in courses on diplomacy and peacemaking because it's a wonderful thing with students to do it in the town where it took place, and you can take them out to Wright-Patterson, you can take them to some of the scenes where bits and pieces of the activity took place. And it's very striking if you read Richard Holbrooke's book on the subject of the Dayton negotiations, that he's very clear that you had to have Slobodan Milosevic intimately involved in those negotiations, otherwise there was no way you were going to get an accord ending that. But he was also clear that involving Milosevic did not preclude the pursuit of justice through the ICTY thereafter. And on the gender-based, I had the occasion in 2005, shortly before Dayton commemorated the 10th anniversary of the negotiations, of taking a group of students to Bosnia, to Sarajevo, to meeting Michael Johnson, who had been the registrar for the ICTR and was in Bosnia creating a tribunal to handle the lesser fish, as he would put it, the crimes that would not go to come here to The Hague for trial. And one of the things that they were finding, particularly with the victims of gender-based violence, 10 years having passed since the end of the war, was the reluctance, particularly of women, to come forward. They had begun to reconstruct lives. They may have married, they may not have shared stories of what had happened, they had families, and that was a very interesting aspect dealing with the gender-based violence in that particular context, when they were particularly, in this case, it was the tribunal within Bosnia, not the ICTY, in that regard. But let me open it up now to those of you who would like to raise questions, again reminding you to ask you to move to a microphone if you would please, unless you know you can project to the audience. So yes, please, we'll start with you. Do you want to speak from where you are?
My voice will be fine, I think.
Sounds good.
So Dr. Hugh Breakey from Institute of Ethics, Governance and Law, Griffith University in Australia, and I had a question for Professor Higashi. So there are different ways in which justice might be a concern, and it may be that an inclusive process is problematic for justice because it needs to ignore criminal justice and retribution on people that have done demonstrably bad things. Equally, looking backwards, it might need to avoid restorative issues for victims who had attacks placed upon them. But there's other ways in which justice might be thwarted by inclusive processes. And this isn't a definitive concern, but it certainly is true that I suppose one could say that inviting the Taliban into the process might not only impact on retributive justice, but might impact upon the future rules of the game going forward, the type of political regime, the type of legislation, the type of constitution even that winds up being crafted as we move forward. And if one had concerns about future human rights, then one might say, well, isn't that a reason then for being resistant to an inclusive process if it's not going to merely sacrifice criminal and restorative justice, but prospective justice, human rights as we move forward and craft a new regime? So is that an additional, if not decisive concern, is it one that impacts upon this equation?
I think we'll let you respond to this since it's a question directly to you, and then what I'd like to do is what others have done, which is to gather 2 or 3 questions for various panelists. Directly relevant.
Yes,
All right.
directly related. You mentioned that a significant proportion of the population in Afghanistan favors reconciliation, which is another way of suggesting negotiation. Were you able to find out whether that is the result of fear and the judgment that without incorporating
Is yours also directly to,
Yes.
all right.
So I think I'll just stand up and make sure I project.
Do move these.
When Dr. Gashi was speaking, a thought came to my mind that isn't it perhaps the case that inclusive political processes contain within them an element of restorative justice? And of course, then I guess it depends a lot on which examples you're thinking of, because you're probably thinking Afghanistan and Sierra Leone. It depends a lot on what we mean with inclusive political processes, but I probably, for me, that would mean a process where the major parties have agreed to and are comfortable in participating in and see a political future for themselves in that. And what I mean with that, and I'll just quickly read it from my notes to make sure I have the right wording in my mind, is that by being included in the political process, people may feel that their pre-conflict inequality has been recognized and partly corrected. And they may feel that they are now in a position to protect and promote their interests through the political process. And this also gives them the choice to pursue other forms of justice or past wrongs in the future if they judge that to be necessary in their interest. So it could be that when you say inclusive political processes, actually it's not a case of that versus justice, but that there's a form of restorative justice built into that concept of inclusive political process.
Please.
Thank you very much for very, very important and very core questions. The first question is very fundamental one. Of course, there's a concern about what kind of government will be created after, if you have some reconciliation with the Taliban, and this is a core part of the negotiation if it will take place. I always argue that maybe the most difficult issue is whether or not the Taliban is ready to embrace kind of democratic election as a method to choose the government. And if they don't agree on accepting those kind of mechanism of choosing leaders, it may not be so easy actually for the government of Afghanistan to make kind of political settlement with the Taliban. But once Taliban, they are not making it clear. They continue to make some kind of declarations about what kind of government they want to do. They want to continue to say that they want to expel the US forces first from Afghanistan so that Afghanistan become independent. But they are not so clear about whether or not they will decide to follow the kind of democratic election. So if they agree or accept that concept, I think many things could be happen. Could be happen mean that once you might create some kind of democratic government by the elections, it could be possible to prevent some kind of, not amnesty, but without justice, by establishing some kind of very solid justice systems, as Japan made a very strong justice system after the World War II. But in terms of the past crimes, many government officials in Afghanistan actually committed crimes during the civil wars, and they become vice president or they might become ministers. So Afghan Congress parties or Afghan Congress leaders already adapted to law of amnesty, so that almost every peoples who committed crime during the conflict, the civil war, will not be prosecuted. This is what Afghan leader decided. So if that's the case, maybe international community or international organization like United Nations might want to support that directions by the local leader if they want to pursue the peace first. Of course, after 10 or 20 years, they might start some kind of different process of prosecuting some war criminals, but it might take some time. This is my point. In terms of the popular, people's perceptions, it's not only the result by my opinion surveys. Asian Foundation, which is like a U.S. organizations or NGO, conducted opinion survey in Afghanistan almost every year, and they conducted 6,000 people's interviews. And in 2010, 84% of the Afghan people supported kind of process of the reconciliation which we supported starting. So I think it's a kind of majority people's perception, and the reason is that they already fought the war for 30 years, and maybe they recognize that without having that some kind of reconciliation or political settlement with the Taliban, it seems to be quite difficult to stop the wars. Maybe this is a kind of conviction of the Afghan peoples, and if Afghan people think in that way, it could be legitimate for the international organization to support that kind of process. The last thing is in terms inclusivity. Yes, I agree with you that inclusive process might have some component of the future justice or future jurisdictional systems. Important thing is that you do not have some specific political exclusions against some specific political party or ethnicities. And once you exclude some specific groups from the participating in the new government constructions, it's almost sure that they will become insurgent and become rebels. So I think it's very important to stop stop that kind of occurrence. Yes. Yes.
Gentleman over here, and Kurt back there, and then I'll go over this.
I'm Michael Platzer, and I'll use your microphone just because my voice is getting weaker, and I think it's good
Thank
to
you.
use the equipment that we got. All right. I would like to congratulate the organizers of the panel, such a variety of topics, but I'd like to address Sash, I think is your name, and talk about the gender-based issues. I heard you say you want to ignore the national boundaries and focus on groups. I would argue that the most important task, and I think Ramesh talked about it, is the establishment of the rule of law in a country again. And that, someone said this morning, is done through robust prosecution and also the judiciary. We've done a thing on Acorns. Vienna, Austria has produced a publication that's available here. It's about targeting of women in conflict. The argument in this book is largely that it's a continuum. It's not, it starts already from gang violence, which a lot of our young soldiers are interested. Lawlessness, it starts about spitting at certain women. It ends up with mutilation and killing of women and girls. It's not just the sexual violence on the one hand. And on the other hand, there are stages in the post-conflict recovery whereby you can start to move towards taking care of your own problems rather than looking toward international law. And I think the important thing, in fact, is to make sure the laws work locally and it's seen as a crime locally, not an international crime, but it was a murder or it was a rape or it was a gang rape. And I think some countries are starting to do that. I mean, we have Guatemala, El Salvador, Nepal, Sri Lanka, which are not reaching out for international solutions, but trying to do it locally. And I think there are also technical assistance that the UN can provide in terms of prosecutors' manuals, training courses. There's a Latin American protocol on violence against women for prosecutors there. And the other organs like the UN Crime Commission, the Human Rights Council, the Committee on the Elimination of Discrimination Against Women has been very specific. So we always need to reach for Security Council. That's my argument. And anyone interested in this compilation of speeches is, my friends have a few more copies left. Thank you.
All right, thank you for your, and secondly, yes, Kurt. Can you speak up just a bit, please?
Kurt Mills, University of Glasgow. My voice is going to.
Come use the microphone then. That's why it's here.
Thank you all for a very interesting panel. My question is for Ramesh. I certainly very much agree with your critique of American exceptionalism, and the paradox that's found in there. But there's a second paradox that sometimes when the U.S. doesn't do things, it gets critiqued for not doing things. And so I'm wondering how we square these two paradoxes, square this circle, etc. If it's possible, how do we go about thinking about doing that? Thank you.
It's the old damned if you do and damned if you don't. Yes, we had a third one over here, yes.
Yeah, maybe I don't have to use the
Mike? Use the microphone.
Well, that's what I wanted to address, I think Ramesh and Sasha. I thought I spoke loud enough, but you say no. What I think is missing during the deliberation for the last 2 days, as I see it, is also sort of linked to the truth. We talk so much about peace and justice, but I find that also the truth is very important. And for that matter, I think Ramesh said it so rightly that at the end, power dictates justice and the perception is distorted. And Sasha, you are saying that there's no assurance that sexual violence is increasing. But to me, sexual violence is increasing as we perceive it, and we regard it as a truth, and therefore we have to address it. So what I'm interested in hearing from you too, and maybe Higashi-san too, that where do you put the truth in establishing justice and achieving peace?
Thank you. Ramesh, do you want to lead off responding?
Sure. I mean, Kurt, look, Colin Powell expressed that dilemma best. The world keeps telling us you can't be the world's policeman. Guess who gets the call? Which cop on the beat gets the call anytime there's a mugging in the global neighborhood? I don't think anyone discounts the dilemma. And the answer is indeed going through authenticated multilateral structures and pursuing the rule of law. Once you do that, I don't think the contradiction is there. You cannot exempt yourself and then be the enforcer of the same norms and laws on others. That is the source of the problem. And of course, subjecting the exercise of US power to the moderating influence of the international community and the rule of law internationally is antithetical to the search for complete flexibility and freedom of action as you determine fit yourself. But you want to deny that to others. And that is the source of the tension increasingly. A specific example. I get extremely worried when the rising power, which has a particular resonance for those of us who live in Australia, says, we are watching how the United States behaves. That is how a great power behaves. We are going to become a great power. Philippines wants us to take it to international arbitration or court. If the judgment is in our favor, we will use international institutions to ensure compliance on the Philippines. If it's against us, tough luck. And they say very openly, the United States doesn't sign the UN Convention on the Law of the Sea and lectures us on abiding by the dispute resolution mechanisms of that. Excuse me. So that, I mean, I'm just giving you one example, but that's a very generalized phenomenon. You could get away with it. Washington could get away with it in the unipolar moment of supremacy and primacy. As that fades, it seems to me it is very much in the US self-interest as well to bind all major powers in an emerging multipolar order to collective norms and institutions and laws. So the dilemma is real. And how could anyone living in Australia not be conscious of the fact that we might end up depending on US security for our security? But nonetheless, It is very much in our interest as Australians to have a rules-based global order. And the United States should lead by example, which then makes its enforcement much more effective as well. Truth, Suki, I thought I was dealing with enough difficult subjects. Now you want to talk about truth as well. I think in confused situations, in an untidy...
One thing you said, remember? You are saying that peace is forward and that the justice is backward and retributive. But to me, the truth is that without the justice, as you said, peace cannot be sustained.
Yeah, I agree. Well, you know, my job now is to speak truth to power. But the Holbrook passage that Peggy mentioned, I think is very interesting, because that is exactly what you have had in Latin America. At an early stage, when you come out of the dictatorship of the lost decade, you cannot directly take on the generals. You give them illusions of impunity, if you like, but craft your agreements in such a way that some wiggle room is left so that you can pursue justice against them when your institutions are strong enough and resilient enough that it doesn't. That's what happened to Pinochet. And the fact that he doesn't get convicted, in a sense, no, because you couldn't have taken him on at the start. That's what I'm saying. But you can take him on later. And the fact that he dies wandering, it's not a bad end of justice. Sash.
Should I respond? Sure. Okay, thank you for the question. So here's the thing. I'm not at all saying that nation states or states or the national level is not important. The point I'm making is that knowledge should precede policy and action. Now, I absolutely agree that rule of law implementation requires robust domestic mechanisms, and I'm not at all suggesting that the international level should be our first sort of our go-to mechanism. I think Prosecutor Bensouda made that point very strongly yesterday when she said, you know, international justice is a last resort. But I think it's dangerous to view violence in armed conflict, sexual violence in armed conflict, as part of a continuum with domestic violence. I've seen this in the literature, and I don't really agree with it. My problem with that is that when you look at, sure, I mean, domestic violence against women in peacetime, I shouldn't say against women because sexual violence, of course, includes men and boys as well, but violence in peacetime and violence in wartime, sure, I mean, there's a relationship there in that they both relate to gender. The problem is we don't know precisely how that relationship works. So to say that there's a continuum of violence where somehow the prevalence rates of domestic violence during peacetime are going to help us make sense of sexual violence in wartime, I really don't think there's a basis for saying that. And my simple sort of response to that is look at armed groups within a single conflict, and there are examples of this, where you have one group that perpetrates sexual violence and one group that doesn't. They both come from the same domestic context. So how do we explain that variation? And that variation is everywhere. It's global. There is an interesting finding when you talk about the continuum of violence into post-conflict. So there is data from South Africa, from Palestine, that men who have suffered political violence, there is a change in their perpetration of violence in a domestic context after war. There is data for that. It's from those limited contexts that I'm aware of. So there is evidence to suggest that violence experienced during conflict can carry on into the post-conflict period, and there I think you can speak of a continuum. I haven't seen anything that really justifies looking at the peacetime context and then kind of extrapolating from that into the wartime concept. So that's the point that I would make there. And for the issue of where you place the truth, I would rather substitute truth with evidence, at least for the phenomenon that I'm concerned with. I think truth can be a very subjective thing. You have your truth, I have mine. I think the evidence is what it is. And I don't think that we should manipulate evidence to fit agendas. I think peace and justice agendas should account for the evidence. And so I would really stay away from discussing truth in that context.
Very good. I think we will take one more round. Alistair said start a little late and finish a little late, and so we will take the liberty of doing that, Alistair. Yes, gentleman there, and then Elena back there, and do we have anyone on this side of the room with a question? All right, very good. Let me go in that order, and I'll add you as a fourth. Go ahead. Do you want to come to the microphone?
Yep.
My question is addressed to Peter. Is that correct? Right. First of all, congratulations that you were very successful to get the organization so successful that it became. I was wondering whether there are lessons learned through the process of getting ratified that other organizations such as the CTBT, for example, can take to overcome the ratification difficulties that are going through. Just maybe if you could make a comment.
All right, question number one. Elena?
My question, Elena Lyons, University of Pittsburgh. My question is for Ramesh, but it builds on something that Peter talked about. So, Ramesh, I applaud you for bringing in the notion of power. I feel like it's missing when you talked about justice and peace. And I remember one of my mentors, John Pacello, who was a founding member, I think, of ACLU as well, talking about power and ideas moving history forward, and that without power you couldn't move history. And so, the thing that is very intriguing to me is American exceptionalism, and you bring that up as President Miller and Kirk there a bit. So, Peter talks about the success of UNCW in Syria. Well, that's really a case study of powerful actors coming together with consensus and moving things forward. But considering American exceptionalism right now, and I actually think of exceptional Americanism, where the United States is a bit of a narcissistic element right now, and making an exception rule of law for it in many cases. How do we instrument, and I'm going to push a little bit further than I think the answer is correct, how do we instrument the peace, international peace, and the instruments of international justice move forward without these powerful actors? I mean, does one look for other powerful actors that may not share the same ideas of the rule of law? Does one look for building consensus among new powers to create power with other organizations outside of public sector, maybe in the private sector? So that's the question that I pose. So in this triad of peace and justice and power that you created, where does one find the power when some of the great powers and their normative commitments to these ideas don't seem to be wanting to touch?
Thank you. I'm going to go over here and I'll come back to you last. The gentleman at the back there. Oh, you moved over here, sorry.
With due respect to all the lawyers here, I don't know how many are here. The question I'm going to raise kind of adds to the provocations of the discussion is, looks like this narrative of justice and peace and the whole process of peace development is constructed on legalism. And I don't think it is due to superabundance of lawyers in the whole process, in the UN or whatever. And I see complete absence of anthropology. Anthropological dimensions in the process of peace building, peace negotiation, conflict resolution is completely absent. And we are kind of enamored by this linearity of
Shall I finish again?
Well, there was a question to Peter.
All right. Well, perhaps if I go first, because I think Ramesh might have more historically informed, certainly politically more liberal, for comment, perspectives on CTBT and vis-a-vis the CWC experience. Well, I mean, as I mentioned, when the CWC was negotiated, when it was open for signature, it entered into force within 4 years. There was quite a lineup of countries signing on, including some countries that are still outside. Myanmar and Israel, for instance, are signatories that never ratified. But I think, in the case of the CTBT, and I don't want to speak for it, I mean, they obviously have a more complex set of rules in terms of what constitutes entry into force by having a certain number of countries from a certain annex in the CTBT have to come on board. And that's been the rub, of course, given the domestic circumstances in those countries. What I would say is that, I mean, so in terms of what experience we can impart to the CTBT in terms of its ratification, well, we don't have an experience that's relevant to its circumstances. I know from my colleagues there that they've gone through all sorts of hoops and all sorts of maneuvers and pirouettes and gavottes to sort of work out a different way of approaching this. It's just, I mentioned before that unlike the NPT, we're non-discriminatory, so that's the beauty of the CWC. And unlike the BWC, which also bans a whole class of weapons of mass destruction, we have a verification regime. And unlike the CTBT is just as good as we are in terms of having a gold standard verification regime and all these great provisions, but unfortunately it has the disadvantage of not actually having entered into force. So I think that disparate experience doesn't really allow for us to sort of provide some suggestions there. The other thing I would mention is that historically, of course, some of those countries are already getting rid of their stockpiles. I mean, the US and Russia, a lot of them were dumping them at sea before it was banned and so on. And just on the point on the US and its contribution, well, I mean, I'll only give the facts. I mean, I'll leave the theory and the context to Ramesh. But certainly in the case of the Syria mission, the US had a vital role to play in terms of its in-kind support, in particular in relation to hosting the destruction facilities when a political solution couldn't be found, when we couldn't find a country willing to provide land-based facilities, we came up with a sea-based solution by courtesy of the US putting a couple of its tried and tested hydrolysis platforms on board a ship and doing it at sea. And even before the environmental lobby could really consolidate its arguments against this, it had already been done, safe and sound. So I don't mean to be disparaging in any way, but there was a lot of misinformed commentary about this at the time. So that was vitally important. But even more important was US-Russian cooperation. That framework agreement I referred to was the basis for the OPCW decision, the decision of the Executive Council on a program of eliminating serious chemical weapons. Having the US and Russia on board was vitally important in that regard, and I think history will show that. But more importantly, as frictions that we all know about in relation to the crisis in Ukraine and so forth came into play, that cooperation didn't really suffer. I mean, in terms of the mission, getting the kit out of the country and destroying it. So I would just sort of leave that as a factual comment on that particular mission.
Before I turn to Ramesh, I'm going to ask Sash and Sakusa, excuse me, if you have any final comment you want to make, then we'll.
Sure. I have sort of one clarification as I sat here thinking about my previous response, which I tend to do, which is that I want to clarify that it's important, I think, when we talk about the link between research and policy, to make a distinction between the unit of analysis that you use to understand a problem and the level at which you address that problem. And that's just something I want to make very clear. The point I was making is that it is more useful, in my view, and in the view of many researchers in this field, that it is most useful to focus analysis at the level of the armed group, to use that as a unit of analysis, to understand a phenomenon so that you can better address that. And your response is obviously going to happen at multiple levels, which includes the international system, the national system, within armed groups. So all of that comes into play. But I'm trying to focus a little bit more on understanding first what we're trying to address before we get gung-ho about addressing it.
Yeah, in terms of the questions about truth by Mr. Hasegawa, I think finding truth is one of the key components in addressing grievance of the victims. I made several documentary about the victim of domestic violence. So I keep interview many people who were familiar in homicide or killed, and they really want the criminal to be punished, but also they really want to know why their family are killed. So I think the reason why we tend to have the name of like a Truth and Reconciliation Commission is that it's very important to inform the truth to the victim so that they can start some kind of reconciliation process. So I think finding truth is very key component. I also really appreciate mentioning by Miss or Dr. Kans and also Ramesh about the reference to the Holbrooke. Actually, it was Holbrooke who embraced kind of my proposal when my Japanese special envoy for Afghanistan, Pakistan passed my article to the Holbrooke, and he asked the Japanese government, because Japan already decided to support that kind of mechanisms. Holbrooke asked Japan and the UK special envoy to start coordinations of making a reconciliation mechanism. So Holbrooke, I think, really understood this kind of ideas. And I agree with you that after 20 years, it might be better to start some kind of prosecution process. My question is that the insurgency also might learn from the lesson. So even if we give some kind of amnesty, they might start suspicious that we might be prosecuted after 20 years has passed. So maybe this could be one of the fundamental challenges for the peace negotiation in the future by the United Nations. I will pass the hand mic to the Ramesh. I really respect Ramesh, who can express what we tend to keep in thinking in our heart, but very difficult to express.
On that note, let me make two brief comments. The first question about the lessons of CWC for helping the CTBT enter into force. I would put it the other way around. The CTBT is unique in the annals of arms control agreements. It's a lesson on how not to have an entry into force formula. If you had had that formula, the NPT would still not be in force, CWC would not be in operation, the Convention on the Law of the Sea would not be in operation, which makes you wonder what the real motivation was behind that, because it was a contentious issue at the time, and I took part in that debate. And certainly my government's position was not to have this peculiar formula. So that's one thing. And I think even now, realistically for the foreseeable future, it will be easier to change that formula and have a standard entry into force formula. Remember what we had last night, when you have 30 ratifications, that aggression article, I think, becomes relevant for the ICC as well. It's not every state that is relevant has to ratify before it becomes operational.
You might just mention what the provision is for the CTBT.
The CTBT provision is there are 44 states mentioned in Annex A which have significant nuclear programs through reactors and stuff. All of them have to ratify before it can enter into force. There are 8 holdouts that includes insignificant countries like the United States and China and India. So that's the position there. Dr. Matero, on the question of anthropology and the abundance of legal terms, well, I'm sorry, but the title of the panel is Balancing Law and Politics. So we were steered towards that, directed towards that, and being good at obeying some instructions, we took that to heart. So those are the easy ones. Let me combine the other two on the non-state actors, MNCs in particular, and back to the US exceptionalism. Again, like Sash, let me make it very clear. My critique of US actions is specific to a particular time and a particular approach. Overall, when the United States acts as a force for the good, there is no other country in the world that comes even close to that. And we have seen a very good example in recent times in the way the US Department of Justice has gone after FIFA. Typically, any effort to apply US law extraterritorially produces cries of legal imperialism. this case, the universal reaction around the world has been, God bless America. Now, if you take that more analytically, we lack an international law enforcement and judicial system to monitor, police, and enforce anti-corruption in world sports. In the absence of that, only the United States has the geopolitical clout, the legal, technical, and bureaucratic capacity to reach wherever the wrongdoers may be and bring them into the criminal justice system as a result of, in particular, the 1977 Foreign Corrupt Practices Act. And they have gone after these guys, and we have all applauded that. But this is an example of enforcing the rule of law without exempting themselves, although, again, I might actually weaken that. There is an element of double standards even there because they use their power to shield American companies and American individuals when they get caught in foreign jurisdictions. And to my mind, given where I come from, the most notorious example is taking out the guys instead of allowing them to be prosecuted for the biggest industrial disaster in history, the Union Carbide leak in Bhopal in India. So there is that double standard even there. But basically, to go back to the question of U.S. exceptionalism, you know, I'll be all in favor of bringing international firms within a rule of law as well. So that's not a big issue for me. Happy to support that. In a sense, the point behind the Global Compact for the UN was to try and instill civic virtue as understood and defined by the UN into the global marketplace as well. So it's part of that agenda. But the basic point is, more than any other institution, the United Nations has somehow to resolve the creative tension between realpolitik and idealism. It is fundamentally a political project and a normative enterprise. As an idea, it symbolizes the solidarity of the human family across national borders. It exists so that peoples who are condemned to die in fear learn to live in hope again instead. Want gives way to dignity. Apprehensions are turned into aspirations. This normative enterprise takes place through particular structures and personnel, with all the imperfections of any human system. We try and improve the structures and the personnel and the methods without abandoning the ideals. Part of that creative tension, when I said that the pendulum of history has swung away from pure power towards normative end, it doesn't mean that power is irrelevant. How do you then harness power in an emerging multipolar world? Power which is national. How do you harness that to international authority? As opposed to appropriating and subverting international institutions and international authority to pursue your power-driven or commercial calculations. In that tension, all changing powers have to be brought into the conversation. And the civilizing influence of that shared normative enterprise, still brilliantly articulated and encapsulated in the UN Charter, is not a bad means by which to try and do that. And the ICC and International Criminal Justice Enterprise is part of that evolution. But what worries me, and I'll finish with that, I think this has been an extraordinary ACONS conference. I've attended several. I think this has been one of the richest series of ongoing conversations. But as the conversation goes on, it occurs to me that the international liberal order is again an expression more than anything else of the US engagement with the international community and creating institutions and trying to pursue the rule of law. Will that international liberal international order come under threat as we experience power shift? And what does that mean for the Hague institutions in particular? Because they are part of that project. So I think there is a very big agenda out there that all of us who are concerned about should address, and any continuation of exceptionalism or double standards adds to the risk rather than diminishing the risk, and that is my concern.
And I think Ramesh has just identified what could well be the agenda for a year in that respect. And as an American, I would say that the issues are not just in the international realm, but I think the issues of the future of a liberal order are very much at risk within the United States, given the turmoil in our own political system, the difficulty of finding compromise now at many levels of politics within the United States. And I'm not overly optimistic.
Your
frankly.
Congress is a wonder to behold.
Well, on that note, I would like to ask to thank you as an audience for some very good questions, and ask you to join me in thanking our panelists. And on behalf of Akins, I have a little something for each of you.
That's great.
Thank you.
Sash, this
Oh,
is for
thank you so much.
And these
Sure.
each.
For those